My name is Shamtoli Huck, and I'm the editor and attorney at Law at the Margins. You can find our chats like we will have today, as well as other articles at lawatthemargins.com. Law at the Margins is an innovative and dynamic social media platform, and it's intended to elevate issues on law and social justice. It's intended as a hub for organizers, activists, academics, and lawyers to come together, share information, and to share strategies. We've been hosting a number of Google Chats to raise issues around law and justice. And today, we're very excited to actually have our first webinar. And our guest today is Professor Garcia Hernandez. Professor Garcia Hernandez is a visiting professor at the University of Denver Sturm College of Law. He is also a fellow blogger, internet, social media maven. His award-winning blog, crimimmigration.com, has won a number of awards. And most recently, in August, he put together the first comprehensive book on crim immigration law, which is essentially the intersection of criminal law and immigration. And you can find that book on his website, crimimmigration.com. So today, what we're going to talk about, it's going to be difficult to cover the vast field of criminal immigration law. But what we asked Professor Garcia Hernandez to speak about is the area of where criminal offenses have had immigration consequences. We've geared this presentation today toward new lawyers in community-based settings, as well as organizers who interact in communities impacted by immigration and criminal law. And primarily it's because we want to give this information to those who are on the ground doing this work and sharing the expertise of Cesar. So the format today is we're very excited to have 35 registered participants. So the format today is that I'm going to hand it over to the professor to give a sort of overview focused on drug and criminal offenses, and then we will reserve a few minutes for Q&A. So those who are listening, what I would encourage you to do is use the chat feature on the right-hand side. I will be monitoring that, and at the end, periodically summarizing some questions for the professor. We want to make sure we maximize his time with us. We'll go until about 1 o'clock, 1:15, and at that point, open up to Q&A. Again, so at this point, I want to hand it over to Professor Garcia Hernandez. I want to thank him for really giving his time. He's doing a lot of tours around his book, and I appreciate his giving the time to Law at the Margins. So, Professor.
Thank you so much, Shamtali. It's really an honor to be here with Law at the Margins, and I especially want to give thanks to you for sharing some of this space that you've created on the internet. I've been fortunate to be following Law at the Margins for quite some time now, and so it's an honor truly to be able to participate in this community. I also want to give thanks, of course, to all of those of you who are joining from around the country today, participating in this webinar. I know that your time is extremely valuable, and I truly appreciate you lending some of it to me to talk about, as Shamtali said, the area of law that I have been immersed in for several years, and that I'm really quite passionate about. I've been teaching and writing about this intersection between criminal law and immigration law for several years, and I invite you to take a look at my blog, crimimmigration.com, and of course also my book, Crimmigration Law, which the American Bar Association published just a couple of months ago. So is very much still fresh off the print run. My goal over the next 20 minutes or 25 minutes or so is to proceed in three parts. So let me lay those out, and then I'll jump right into things. First thing is I want to explain what crimmigration law means, what this term, this phrase refers to. Second, I want to talk about immigration law developments regarding drug crimes. And the third thing I want to do is I want to explain how it is that we reached this point in the evolution of criminal and immigration law in the United States, at least. After that, we'll have some time for questions, and so I hope that you will take note of anything that you want to discuss in more detail, and I'm happy to address that to the extent that I can. So before we begin talking about the substance of immigration law, we need to be clear about what that even means. It's a fairly new term, and so we need a working definition of it. And that's one of the things that I've been engaging in over the last several years, both on the blog, my classes, and my scholarly articles, but also in the book that I just came out. So to me, immigration law consists of three different strands. First, there's the expanded number of crimes that can lead to immigration problems. Second is there's the increasing amount of migration-related activity that can and often does lead to criminal prosecution. And the third thing is that there are unique or uniquely harsh methods of regulating the lives of migrants that I think cannot realistically be described as either criminal law enforcement or civil immigration law enforcement techniques, at least as we've traditionally understood those categories. I write about each of these strands on crimmigration.com and in Crimmigration Law, the book, but naturally I can't go into all of that. Besides, I don't really want to. I want you to take a look at the blog and even take a look at the book as well. So I'm not going to deny you the incentive to go and do that. Instead, I'm going to simply highlight some of the developments that address low-level drug offenses in particular. And you should have received an outline of this presentation earlier that includes excerpts from my book that are relevant to this material. I address much of the legal doctrine, or a lot of the legal doctrine about illicit trafficking in drugs, which is a type of aggravated felony, about controlled substance offenses, and some material as well from the book about the Sixth Amendment right to counsel. I'm not going, because you have that available to you, I'm not going to simply reiterate that. You guys can take a look at it on your own. And follow up at the end of this presentation with questions, or always feel free to get in touch with me after the fact. My contact information is available on the blog crimmigration.com, so you guys can just always shoot me an email, and that's the easiest thing after this event. But let me jump right into how immigration law is affecting the rights of migrants with regard vis-a-vis, in particular, low-level drug offenses. So to do that, let me begin where I think immigration law begins, and that's with an expanded appetite to remove migrants who have committed a remarkably large number of crimes. Now, historically, crime was punished through the criminal justice system. This was true for United States citizens as it was true for migrants. The fact is, usually legal troubles ended there: an acquittal, a conviction, got convicted, some punishment, but that was by and large the end of the story. All of that began to change in the mid-1980s, and it began to change in particular as part of the war on drugs, or at least the early legislation that we now have come to know as the war on drugs. During that mid-1980s political milieu, Congress and multiple presidential administrations steadily added to the list of crimes that could result in removal from the United States. No statute better illustrates this change than the Anti-Drug Abuse Act of 1988. As the title suggests, as the name suggests, it was intended to target illicit drug activity. And it did that, to be sure. It did that in many ways. But it also added two little words to the Immigration and Nationality Act, the federal statute that governs immigration law, that have changed the fortunes of literally millions of migrants. And those two words were aggravated felony. Now, the concept of the aggravated felony began with a definition that reached all of three crimes: murder, illicit trafficking of firearms, and drug trafficking. Now, today, many decades later, it includes 21 categories of offenses, including some that are neither felonies nor particularly egregious violations of a crime. In other words, neither the word aggravated nor the word felony carries its usual meaning when it's used in the phrase aggravated felonies. Now, lawyers are wordsmiths. One of our primary responsibilities is to interpret the meaning of words used in laws. Now, though that sometimes leads to undesirable outcomes, and there's absolutely no shortage of those in this area of law and in other areas of law, in the illicit trafficking and drugs context, at least, it can actually lead to some migrant-friendly results. So let me point to one of those at least. One limitation on the definition of trafficking in drugs deserves special attention by advocates. There's a 2006 Supreme Court case in which the court made it quite clear that trafficking requires some kind of commercial activity. Giving away drugs is not enough for a conviction to constitute illicit trafficking as far as the aggravated felony definition is concerned, which can then lead to removal from the U.S. You actually need to have received some kind of remuneration. Usually this is money, not exclusively, but usually it's money, in exchange for those drugs. Likewise, the controlled substance offense provision is broad, and it can result in removal from the U.S., but it's also not limitless, and we need to try to focus on those limits as potential places where advocacy, creative advocacy, can actually work in favor of migrants. At bottom, the controlled substance offense provision raises the stakes for anyone who's been convicted of a law relating to a controlled substance. It could be a foreign government, a state law, federal government law, it doesn't matter. And it does this language relating to a controlled substance raises the stakes because that language is obviously quite broad. Almost all drug offenses, to be sure, fall within its reach, but importantly, not all offenses do. To constitute a controlled substance offense, a state conviction must have involved a drug that is punished by the federal government as well. This is not an irrelevant consideration. Many states, in fact, criminalize possession of substances that the federal government does not. Anything from certain types of hormones to traditional stimulants like khat. This is one result of just the fact that Congress has been gridlocked for years. They haven't managed to enact all that much legislation, and so there's some discrepancy between substances that the states criminalize as drugs, and some that the federal government doesn't. And in that gap, the fact is that those offenses may not lead to removal from the U.S. More importantly, this discrepancy between state convictions or state drug laws and federal drug laws becomes relevant for exactly the same reason that the commercial activity requirement in the illicit trafficking context does. And that's because immigration judges determine whether someone is removable from the United States based on a rather quirky framework that we call the categorical approach. Now, I won't describe the categorical approach in its full glory right now. I write about this a lot on the blog and a lot in the book. But I'm happy to take more questions about it after the fact. But instead, I'll say this about the categorical approach. The categorical approach forces attorneys and judges to of and not what a person was accused of. This means that the most important work for advocates is to consider what the conviction documents say about a person's conduct, and not what the police officer or what some other witnesses said the migrant was convicted of. This is hugely important in the present day when almost all convictions at the state and the federal level result from pleas. People are often accused of a whole host of things and end up pleading guilty or pleading no contendere to a lesser offense or only one of multiple charges that were originally lodged against them. And so what we need to focus on in terms of deciding whether a particular migrant is going to be potentially removed from the United States is not on what they were accused of, but on what they were actually convicted of. So if the conviction does not require payment in exchange for drugs, or if it leaves open the possibility that the conviction involved a substance that was punished by the state, but that's not punished by the federal government, then the migrant has some breathing room. Now, under Chief Justice John Roberts, the Supreme Court has certainly arced to the political right, to the ideological right. But it's also provided migrants and their advocates with some legs to stand on. And these two are just examples. There are certainly more. But what they all have in common is this. They emphasize the importance of attorneys thinking strategically and thinking creatively from the very beginning of the criminal process. In 2010, the U.S. Supreme Court issued a landmark holding in Padilla versus Kentucky. The Sixth Amendment right to counsel, the court announced, requires criminal defense attorneys to provide their non-citizen clients with advice about the immigration consequences of a conviction. At the heart of the court's opinion was a realistic recognition that the traditional division between criminal law and civil administrative immigration law has blurred to the point of irrelevance for many migrants. The ability to remain in the United States, it's often preserved or it's lost inside the criminal courthouse. Now, add to this the fact that about 95% of convictions result from pleas, as I mentioned earlier, and we're left with a situation in which the most important advocate for the migrant is often not the attorney who appears before an immigration judge, but it's instead the attorney who appears before a state criminal court judge where most convictions result. This led the Padilla court to conclude, let me just quote the court, "We find it most difficult to divorce the penalty, that is deportation, from the conviction." So in Padilla's aftermath, courts have had to decide whether its holding applies to convictions that precede March 31st, 2010. That was the date that the Supreme Court issued the Padilla decision. They've had to decide whether a judge's warning that pleading guilty might have adverse immigration consequences, whether that advice, by the general advice provided by a judge, somehow remedies a criminal defense attorney's failure to meet the obligation to provide representation that meets prevailing professional norms, an obligation that has been with us since 1984, when it was announced by the Supreme Court in a case called Strickland versus Washington, and it has evolved ever since then. The lower courts have had to decide whether the states can foreclose these Padilla claims through quirks of state procedure, whereby a migrant can be convicted for immigration law purposes, but not for state law purposes. And 5 years after Padilla, we're now in 2015, so it's just been just over 5 years since the Padilla decision was issued. The Supreme Court's actually taken up one of these issues, and that's the question of just how far back in time Padilla's reach extends. And yet, despite that, state and lower federal courts are still struggling with all of these issues. And I track a lot of this material, I try to track a lot of this material on the blog, and I write about it in the book. And so this is material that is evolving every single day. So why did this happen? How did law on the books and law on the ground transformed so much that immigration attorneys now spend countless hours sifting through penal codes, that criminal attorneys have to ask themselves whether a plea is going to bring ICE to the courtroom door, the Immigration and Customs Enforcement Agency. All of this resulted from the most perverse of American traditions: fear-mongering and race baiting. For roughly the last 30 years, immigration law has been subsumed under a rhetoric of criminality that frames the migrant as the specter of dangerous. In the 1980s, for example, Ronald Reagan warned that Mexicans and that Central American migrants were a potentially traitorous group. Some of these folks, he said, were already inside the United States, and millions others were at or were just a short drive away from the southwestern border, and they were all clamoring to get into the U.S. Now, Reagan didn't have to explicitly describe these migrants as members of any particular race. The point was really quite hard to miss. These brown-skinned newcomers from the South represented a danger to the way of life that white voters longed for, and in defense of which they would cast their votes for the man who signaled he was on their side. Now, framing migrants as dangerous allowed multiple presidential administrations of both Republican and Democratic parties, always with the support of Congress, sometimes the Congress controlled by Republicans, sometimes one controlled by Democrats, to entangle criminal law and immigration law to create crimmigration law by following a fairly simple script. First, frame migrants as dangerous, and then strong-arm governmental responses become necessary to ameliorate that danger. And you do so without ever explicitly uttering any racial hostility toward migrants. So take what happened in 1984 as an example. In that period, there were thousands of poor, dark-skinned migrants who were making their way to the U.S. from the port of Mariel in Cuba. And these were supposedly, they were described as supposedly being the cast-offs from Castro's prisons. With little basis in fact, U.S. News and World Report, which at the time was an actual magazine, it was an actual reputable journalism site, and not just a ranking service. At the time, U.S. News and World Report published an article about this this phenomenon that with a headline that encapsulated the dominant political rhetoric of the period, and that headline was "Castro's crime bomb inside the U.S." So it was U.S. News and World Report was very much framing these migrants as dangerous, as criminals, and framed as such. It was only a matter of time before government officials responded to this danger, and so they did. Crimmigration law's fascination with imprisonment is a key illustration of the rhetoric of criminality in action. During the 1980s and the 1990s, the Reagan administration, the Bush administration, the Clinton administration all responded to the perceived danger posed by migrants by turning to the state's policing authority, in particular its ability to imprison as the preferred remedy for immigration law violations. In fact, that U.S. News article, it was accompanied by a photograph of folks who were called pejoratively Marielitos, and the photograph caption described them as being housed at a federal penitentiary in Atlanta. The reason why imprisonment became the policy of choice was because imprisonment appears to apply equally to everyone. Anyone who breaks the law is subject to confinement. Don't break the law, and you won't be detained. These policies can pass as racially neutral and their proponents as racially agnostic, but in reality, they're anything but. What this race-neutral tale misses is the racially skewed nature of immigration lawmaking and immigration law enforcement. It's certainly true that Latinos violate immigration law more frequently than non-Latinos. A decontextualized assessment of the situation suggests that Latinos are simply more immoral than others, that our disrespect from the law is evident in the fact that we constantly break the law. And complaints about illegals can thus be couched as concerns about the rule of law rather than concerns about the changing racial composition of our neighborhoods, and it can do so without ever referring to race. But that's, of course, not the end of the story. Understanding immigration law's development requires appreciating some historical context. Mexican migration to what is now the United States has preceded creation of the border, and it never stopped. During much of the 20th century, Mexicans traveled to the U.S. as temporary farm workers under a program called the Bracero Program, a federal initiative. And in the early 1960s, there were upwards of 200,000 and 300,000 people, Mexicans, who were coming to the United States every year with the federal government's authorization to work. That all came to a quick halt in 1964 when the Bracero Program ended, and all of 1 year later, Congress enacted the Immigration Act of 1965, what some of you may have heard referred to as the Hart-Celler Act of 1965. It's the same law. One of the major changes that the Immigration Act of 1965 brought forward was a limit on how many migrants could come from anywhere in the Western Hemisphere, or from all of the Western Hemisphere as a whole. 170,000 people could be granted permission to enter the U.S. each year from the entire Western Hemisphere. 11 years later, in 1976, Congress imposed a per-country cap on Western Hemisphere migration. Only 20,000 migrants could come from any given country. Now, given historical migration patterns from Mexico in particular, it's not a particularly big surprise that people kept coming to the U.S. Their jobs didn't somehow all of a sudden evaporate. Their families didn't somehow all of a sudden disappear. The only thing that disappeared was their legal permission to keep coming to the U.S. as they had been for decades, sometimes generations. So they kept coming after 1965, and then after that, the additional limitation was imposed in 1976, only they were now coming in violation of federal immigration law. So these policies recast Mexican migration into the picture of illegality. Not surprisingly, Latinos have borne the brunt of ever more stringent policies, and detention statistics illustrate this really quite well, I think. In fiscal year 2012, just to take 1 year as an example, as a snapshot, at least 93% of civil immigration detainees were originally from Latin America. Worse yet, Mexicans and Central Americans from the Northern Triangle region are disproportionately likely to end up detained than other migrants. The moralized claim that unauthorized migrants lack respect for legal processes ignores this history. Instead of acknowledging the policy choices that created unauthorized immigration, immigration restrictionists, they just focus on illegality. And doing that allows them to stoke racial embers without explicitly mentioning race. That is, the anti-immigrant cadre can point to the dangers posed by brown-skinned migrants without ever uttering the word race. This is covert racism turned into facially neutral political rhetoric, which is then turned into electoral action, getting white voters in particular afraid of these newcomers into voting booths to support politicians who would crack down on immigration illegality. And so voters have, electing politicians who repeatedly harp about the dangers migrants pose while rarely resorting to blatant expressions of racial animus. Republican Representative Lamar Smith claimed back in 1987, Smith is still in office, but he claimed back in 1987, quote, Jamaicans, mostly illegal aliens, have developed a massive criminal organization that imports and distributes narcotics. His Republican colleague Steve King from Iowa, who's a major source in the Republican nominating process, or major figure in the Republican nominating process, presidential nominating process, followed suit in 2013, much more recently, also illustrating this rhetoric of migrant criminality by claiming that unauthorized migrants brought to the United States as children, the Dreamers, should not be allowed to regularize their status because, as he put it, for everyone who's a valedictorian, there's another 100 out there who weigh 130 pounds, and they've got calves the size of cantaloupes because they're hauling 75 pounds of marijuana across the desert. Now, framed this way, it becomes inevitable that security would become the principal concern. Legislators and government bureaucrats are disinclined to go easy on ostensibly dangerous individuals. Instead, they have absolutely every incentive to tout as an accomplishment the steel and concrete prison walls and the annual statistics of an ever-growing number of people who are incarcerated and removed because of a suspected or a confirmed immigration law violation. This allows them to show the public that they're doing something about the danger in our midst. And eventually, that dangerousness frame began to build upon itself. Migrants must be confined and removed because they're dangerous. And they must be dangerous because we're confining and removing them. Why else would we go to so much effort? So this story of change that I've talked about for the last several minutes reminds me of a passage from a book that was published in 1881 by the towering legal scholar and Supreme Court Justice Oliver Wendell Holmes. And in a single sentence at the very beginning of his book, The Common Law, Holmes wrote this. He said, "The life of the law has not been logic, it has been experience." In that single sentence, Holmes tells us a lot. He reminds us that law is not static. It's instead a winding path through history. It's a dizzying foray into the vagaries of human nature, an adventure in the unpredictability of legislating. It's a maddening glimpse into the complexities of policing, and it's a test of faith in the righteousness of judicial interpretation. Crimmigration law encapsulates Holmes's vision. It's a product of human experience. It's a testament to the United States' greatest moments and to its most visceral fears, which in the last few decades have been tied up with concern about illicit drug activity. The nation's well-earned self-image of welcoming migrants has been dotted by consistent efforts throughout that history to demonize those same migrants. And despite attempts to penalize migration-related activity, legal advocates who are trained in the promises of equality and the promises of justice have resisted the worst excesses of the state's coercive powers. Crimmigration law, as Holmes suggests, I think is alive. And as with all living creatures, it's constantly changing. It will evolve every day, propelled by perceptions of security or danger, comfort or unfamiliarity. It will move in the direction of further entangling the worlds of criminal law and immigration law if the community from which it has arisen so desires. And it will move in the opposite direction, a direction that I think is more reflective of the law's past, only if the fears of migrant criminality subside. The last 3 decades, sadly, suggest to me that the former is much more likely than the latter. If crimmigration law's creation and expansion shows anything, however, it's that the law is perpetually malleable. Legislators, lawyers, and judges can and will continue to shape crimmigration law's reach. Only time will tell where this infant area of law leads. But the only thing that is certain, and the only thing that I think I illustrate in the material that I write about regularly on the blog and that I've written about in the book, illustrates is that there's going to be much room for contestation as some legislators, some lawyers, some courts, some advocates push to expand crimmigration law, while others push back. My blog and my book are intended as tools for those who are engaging in that work, and so I hope that you'll consider taking a look at both or at either. Let me give you thanks for listening to me for the last few minutes. I now want to turn it over to you guys, and I'm happy to take questions that you may have.
Great, thank you so much. This is excellent, and actually, watching both cats, consistent approach of one raising which impacted communities is not new. However, the importance of understanding the historical context. So I want to just summarize a number of reactions during your talk. I want to invite Yadira, if I can invite as a speaker. She's one of our registrants and asked a couple of questions. One, actually, is someone who's impacted herself. Her cousin was not given the Padilla warning and was deported. And what are some resources that communities, family members impacted can do who are not lawyers? And then also another question regarding how is it possible that someone who is excluded from returning to the United States, and then a warrant is issued for their appearance in immigration court, can be then deported for not appearing? It seems like this, crazy matrix. So those are the two questions, and I don't know if Yadira can add on and speak in this webinar, but if she can, I'd like her to add if I've misstated any of her questions. I believe I just see her sort of joining on. Yadira, are you able to pose your question directly to Professor Garcia Hernandez?
Yes, I'm sorry. I guess I had a question in regards to why is there no communication between the criminal justice system and immigration?
Referring to the criminal defense attorney, and perhaps I'm not sure I understood.
I feel like there's no connection when you have an immigrant criminal defendant, and in court he's either he's charged, and then when it comes to his immigration issue, there's no connection on the fact that he's been either charged or dismissed on the criminal side. So why isn't there any sort of coordination between the systems where it's understood that the criminal non-immigrant has rights also, or different rights on the immigration side?
So I thank you so much for that question, Yadira. It poses or it highlights a big asymmetry that exists, a big gap in how much coordination happens, because there is actually a ton of coordination that is going on between, say, the criminal law enforcement agents, police officers, prosecutors, and ICE, and immigration and customs enforcement agents. But what you're asking about, I believe, is the lack of communication on the advocacy side, on the folks who are actually advocating for the migrants. And I think you're right. I think that there is a resistance and a big learning curve that we need to overcome in the criminal defense community in particular, to teach defense attorneys that they need to be thinking about what's going to happen after a plea is entered, after somebody's found guilty and does some jail time, they need to be thinking about whether that person is going to be allowed to remain in the United States, because for a lot of people, that's really the most significant potential risk that results from criminal prosecution. I think the way that folks who are not themselves criminal defense attorneys, or not folks who are lawyers who are representing defendants, can push defense attorneys to be thinking about that while guiding a defendant through the criminal justice system is by bringing it up, by making sure that you are raising for defense attorneys the fact that the ability to stay in the United States is as significant as jail time, as avoiding jail time, as avoiding a conviction. That conversation needs to happen from day one. If there's a possibility that the defendant is not a United States citizen, then the criminal defense attorney needs to be thinking about that just as much as she needs to be thinking about what witnesses are saying, what the police is saying, what the prosecutor is charging, because by the time we get into immigration court, oftentimes attorneys have their hands tied, and the bigger problem that exists there is that there's no right to appointed counsel. That is, if you can't afford to hire an immigration lawyer, you don't get one. And that is very different from the criminal system, where there are problems, obviously, to be sure, with public defenders and with criminal defense attorneys, but at least you've got somebody to talk to, right? You've got somebody to raise those issues for. And I think the biggest way that non-lawyers can affect that process is by raising the issue over and over again until you get a satisfactory answer, because in 2010, the Supreme Court said, criminal defense attorneys, you guys have a constitutional obligation to talk to your defendants about it, your clients about this. And if they're not doing that, then they're violating the Constitution. So the more you push them to do it, the more likely you're going to get a solid answer from them.
Thank you so much. What do you think we advocates to educate some of the people out there, not just the attorneys, but you have an array of immigrants who don't understand that one attorney doesn't know everything. They need to speak up and ask the right questions, or at least some pertaining to their immigration issue prior to being in criminal court.
Yeah. Let me answer that in two ways. First is we need to be clear with everyone that if you are not a United States citizen, then you are always at risk of getting deported. That's true of people who are permanent residents. That's true of people who don't have permission to be here. That's true of everyone. Everyone who's here on a student visa, if you're here for work, for school, it doesn't matter. You can have the government's permission to be here, but you're always still potentially deportable if you violate immigration law, whether that's through a crime or some other way. And what I often have seen is that we'll have people who have basically lived their entire lives in the U.S. They were brought here as babies or as little kids by their parents, and they've had a green card their whole time. And they just think, look, I grew up, I was born and raised here, I'm just like everyone else, and so I'm not going to worry about it. And the fact is, there's always a risk, and so the only way to avoid that risk is by becoming a U.S. citizen. So if you can naturalize. If you can go through the naturalization process to become a United States citizen, pay the money, study the civics questions and the history questions, do it once, get it out of the way, and that's the only surefire way, or almost surefire way, to avoid deportation. That's the best piece of advice I think that we can give migrants. The other thing that we can, in terms of raising important or flagging questions for migrants is, like, no one's going to advocate for you better than you are, and so you need to be thinking about making sure that you're raising the fact that you're not a citizen with defense attorneys, and you got to do that from the very beginning. And everyone in our community needs to be aware of that, because any kind of run-in with the criminal justice system can result in being placed into the immigration court system, and that is potentially facing removal. Now, you may find a way out of it, and there are ways to avoid actual removal, but no one wants to be in that process in the first place. Being quite clear about trying to avoid interactions with the criminal justice system is great, but the fact of the matter is that sometimes the criminal justice system comes to us. We don't always go to it.
Great. Cesar, I wanted that we bring in other conversation. Yadira, thank you so much. I also want to mention that Suzanne, a participant, also reflected on how this criminalization has impacted her family personally. I want to bring in guest registrant Melinda Barnhart, a former colleague of mine from New York Law School and also an immigration expert. We're going to have one question each. I have also another question from David Proper. So what I'll do is encourage registrants just to ask one question, because we do only have time with a professor to go through 1:30, and I'll try to see if I can summarize some of the questions, and I'll be individually inviting you to ask the question directly, then trying to paraphrase it. So again, Melinda, if you want to ask your question.
Certainly. Thank you, Shantoli, for organizing this. My question is, if there's only one issue that activists would focus on, what would you want it to be? What do you recommend that we as an activist community do that would have the greatest effect on the crimmigration system from a migrant's perspective? Thank you. Thank you.
Thank you, Melinda, for that question. I think the single most hidden issue and the single most important issue is imprisonment. It's the prevalence of confinement as a way of enforcing immigration law. It happens in the civil immigration regime, but it also happens through the criminal immigration regime. The private prison companies are all over this. They're making literally millions upon millions of dollars on this, and so they're invested, right? They claim not to care whether the government enacts harsher laws. I'm skeptical, right, of any business. Every business I've ever heard of cares about what its major customer is doing, what its only customer is doing. So I'm skeptical about their public line on that. And I think this gets overlooked a lot because these are people who are locked up, so they must be scary. And so we tend to just sort of put them out of mind, partly because we put them literally out of the middle of nowhere, South Texas, right, surrounded by onion fields, surrounded by mesquite trees, and so it's easy to pretend that these people are already have one foot out of the United States, when in reality a lot of them are permanent residents who have a basis to stay here, or they might have a legitimate claim for asylum. So we shouldn't forget them.
Okay, great. I want a number of questions. Registrants don't have a feature to ask directly, but I always try to give folks the opportunity. So a question from actually one of your former students, Professor. Colorado U.S. Senator Michael Bennet has talked a lot about immigration during the current campaign. We saw differences between Representative Tancredo and Kaufman's approach. Can you guess any of the upcoming political changes to the laws? Maybe I'll add, since there is a conversation around immigration nationally, not just in Colorado, maybe if you can sort of talk about political changes in the horizon. Another question from David, in New Mexico, not really a question but a statement, that the failure to advise a criminal defendant of his immigration consequences is ineffective counsel and grounds for writ of habeas corpus. So some states do allow it. It seems like some states don't. And so I think just sort of sharing what's happening in New Mexico, is there, I guess maybe from that, are there differences state by state in terms of where not sharing the adviso is a ineffective assistance of counsel? So I don't know if those are questions.
All right. So the first question from Antonio Mendez, my former student, is out there in Colorado doing great work. So I'm happy to see him here. I want to point out, Shantali, that I don't think he refers to himself as Tancredo. I think it's more like Tom Tancredo. And I think he is quite a rabid immigration restrictionist. But the question, I think, arises from the fact that the next Republican primary debate is happening here in Colorado in next the 28th, which is coming up, actually in Boulder, not too far up the street from where I'm sitting in Denver. And so Colorado is a swing state, so just like many other places in the U.S., this is an issue that's been coming up, and we are a state that has a strong conservative basis in the rural parts of the state, but where there is a much more liberal urban core to the state. And so this is a contentious issue here, as it is in many other places. In terms of political changes that I see, sadly, I don't see much good coming. We've seen some of the worst excesses happen under President Obama. Arguably the most liberal president in recent memory, and certainly one that was elected on a message of great liberalism. Senator Sanders has taken a pretty strong stance. Secretary Clinton as well, and Governor O'Malley as well on the Democratic side, to liberalize immigration laws, to reduce the detention population. Senator Sanders, in fact, proposed a couple weeks ago a bill that would preclude private prison companies from getting contracts from the federal government. I'm not particularly hopeful that much of that will actually happen, because I don't see that the Republican Party is going to go away anytime soon, and they have devolved into an irrational opposition. But I also don't see that there is that much support among more conservative members of the Democratic Party. I think there's actually a big divide on the Democratic Party on just how much to scale back detention. Barbara Boxer from California, a fairly liberal senator, was very, very vocal over the last few months about a perceived failure by ICE to not deport a guy who was convicted of a federal immigration crime and then released by San Francisco authorities. He ultimately was accused of killing a woman in San Francisco. It sounds like it was, if he did in fact do that, it sounds like it was potentially an accident where he picked up a gun and dislodged it, a gun that he found under a bench. But Senator Boxer is a great liberal firebrand, nonetheless was really critical of the Obama administration and ICE in particular, as if somehow deporting this guy so that he could kill somebody in Mexico, that would make everything better. I don't take that position. So I'm doubtful that we're going to see any great reforms in the waning days of the Obama administration, or even in the under the next presidential administration. And frankly, anything that does happen, I think if comprehensive immigration reform does get to the precipice of enactment, it will probably be by bargaining away the rights of folks who have a criminal history, a criminal record. So I'm really concerned about the future.
Great. So we have time for only just two last questions in the last 5 minutes. I don't know if Suzanne, I've invited her to ask her question, to go ahead to do that. And then I just want to ask a question from Stella, who is concerned about foster migrant children and foster children, and whether, a lot of, in terms of, I worry about kids, what happens to migrant U.S. kids, foster care deportation, foster parents, if you can share about that. And then again, I want to invite Suzanne, are you there to ask your question?
I'm here. Thank you, Chantoli, and thank you, Cesar. This is very helpful for a new attorney, but my question comes from having been in a situation where a relative of mine was in the same scenario that was brought up in a prior question, and whereas he was not advised as has been put forth under Padilla, and it was recently ruled that in New York State Padilla is not retroactive, and in the case of my relative, I mean, he's already been deported, but so my question is, how are lawyers and communities building strategies to support those who don't fall under, who agree to guilty pleas prior to the Padilla ruling? So what are the short-term strategies and long-term strategies that also are inclusive of those who have already been deported, for both lawyers and community organizations? Thank you.
Thank you very much for that question, Suzanne. Yeah, so this actually relates to David's question, which I didn't get to earlier, but there is a great amount of variation at the state level right now with regard to whether the Padilla versus Kentucky decision applies to convictions that were entered prior to March 31st, 2010. A number of states, like New York, have come to the conclusion that it does not, and therefore people who were convicted in violation of the Constitution, that's okay as long as it happened before March 31st, 2010, which is a problematic position, but to say the least. But in terms of short-term and long-term strategies, the short-term strategy, of course, is to push, continue pushing ICE to exercise their prosecutorial discretion to not move forward on those convictions. If you have a conviction from prior to March 2010, then you're at least talking about a 5-year-old conviction. Oftentimes we're talking about people who have been convicted 10, 15, 25 years earlier, and if they've been living a perfectly law-abiding life, or at least a life in which they haven't been convicted of anything else. I say that only because we all commit crimes all the time. As I tell my students, on the way home, you will commit a crime because you're almost certainly going to be speeding. So I think we need to be pushing ICE to look at people's whole situation, their whole lives, and say, look, this person, yeah, maybe was convicted of something 5 or 10 years ago, and that's unfortunate. But they've also been working, and they also have a family, and they're also raising these kids and doing all the other things that we all do, right? Good things and bad things. And ICE has the ability to decide not to move forward with a particular case, no matter what the strength is. This is true of criminal prosecutors. It's true of immigration prosecutors as well. Prosecutorial discretion is a key component of every law enforcement regime known in the United States, and so we need to be pushing ICE to say, look, just because you have a conviction on your record doesn't make you a person who shouldn't be part of our political community. We're going to look at all of you. In terms of a long-term strategy, that's legislation. That's to continue to build community mobilizations that are going to pressure our members of Congress to disentangle criminal law and immigration law, to stop using a criminal history as a marker of undesirability. That only Congress can do that, and so that's the long-term strategy.
Great. And did you want to share?
Oh, right. Stella's question. Yeah, let me quickly address that. So that's a really interesting and complicated a piece of this story, and it's interesting because the way in which it often occurs, the foster care system often becomes involved, is by having a parent who has United States citizen children get picked up by ICE, get detained by ICE, and get thrown into the immigration court system, the removal system. Of course, and when they're detained, they of course can't parent, and so oftentimes parents will have a backup plan. Sometimes they don't have a backup plan, or that backup plan doesn't get activated for whatever reason, and so the kids get taken into the child welfare custody, and they get put into the foster care system. And some courts have used detention and then deportation as a basis for terminating parental rights. That is a really, really difficult position for a. It is really difficult for a parent who is in immigration detention or who gets deported to do anything about that. They're often not brought to the parental custody hearings. Sometimes they don't want to tell the ICE officials that they even have a kid because they're afraid of what will happen to the child, and so the foster care system becomes the way to that we deal with these children. And I think this suggests the problem with relying so heavily on detention with people who aren't dangerous, who aren't necessarily a flight risk. Like, the fact is, like, people get to stay in the U.S. Just even if they don't have permission to be here. There are ways of avoiding removal. And so we shouldn't just assume that everyone's just going to disappear into anonymity or is going to have somehow endanger the community just because they're facing the possibility of removal. If there isn't any legitimate reason to detain them, then we shouldn't detain them. And if we don't detain them, then they'll get to go back home to their kids while the immigration process, makes its way through the system, and that'll avoid the entire complicated picture of foster care.
Great. So I time, and I want to thank Professor Garcia Hernandez for giving his time in the planning of this webinar and obviously talking to us today. Consistently from all the participants, specifically from Yadira, I'd just like to thank you, Professor Hernandez, for your thoughts and your time. A comment from Young Min about retroactivity, that it seems so unjust that we have laws that are applied, criminalization law applied in some contexts and not others. We won't have time, to address all of these really important issues. I want to thank all for listening. This webinar is going to be recorded on YouTube, and please encourage and share with others. Again, I want to encourage those who found this topic interesting to look at the professor's own blog, crimimmigration.com, to look at his ABA book on this topic, which to my knowledge is the first comprehensive legal mapping on this topic. It's not a new topic, as some of our registrants who are impacted by criminal immigration law reminded me. This is not a new issue impacting communities, but amongst lawyers and many other folks, this is something that we're just beginning to grapple with. The last thing I just wanted to highlight is it seems to me that there was a lot of requests for self-help strategies, things that impacted communities could do, and access to legal resources, places that they can go to when their family members, communities are impacted. And I don't want to put you on the spot, Cesar, but if you thought maybe you and I can work on making that some kind of self-help type of strategies available, and we'll make that available on the law@themargins.com site, so that folks who participated today that are non-lawyers, who can't afford lawyers, since immigration court does not give you really a public defender, we can at least make this information accessible. So I want to thank you, I want to thank the registrants, and then finally I want to thank Albert Garcia, who is the tech producer for Law at the Margins. If there are other topics, not just on immigration law, on labor rights, on law and social justice that you want to have know your rights information on, please let me know. This is the whole purpose of Law at the Margins, is to bring together lawyers, organizers, impacted communities on one platform so that we can share information, share strategies, and really be all on the same page. Again, I want to thank everyone. I don't want to know if, Professor, you want to have any final words, but I'm signing off. Thank you so much for your time.
Thank you, Chantal, and thank you everyone else for participating.